Good morning. Please let me start by introducing myself. My name is Sarah Page, and I'm a newly admitted lawyer working in a community legal center based here in Brisbane. My main area of practice is family law. I have here as well with me today my colleague, Mark Marais, who is also a lawyer practicing in family law at the Community Legal Center. It is an honor to be presenting to this group of esteemed healthcare professionals about a topic that is really important to my colleague and myself. Today we will be refreshing this group on the laws regarding surrogacy in Queensland. Healthcare providers are often the first source of advice to a potential surrogate or family seeking a surrogate and who they will turn to. Staying informed on Australian surrogacy laws, which are fragmented and inconsistent, varying from state to state, is especially relevant to your profession and important to the community that you serve.
As Sarah mentioned before, surrogacy laws do differ from state to state, and while it is good to keep that in mind, as you are all medical practitioners in Queensland, we will focus our lesson on the relevant Queensland surrogacy laws today, and we'll touch on the differences in other states and territories briefly. Before 2010, all forms of surrogacy were illegal in Queensland. Surrogacy laws across Australia have changed significantly over the past 25 years, with several reviews of the laws and subsequent reports published regarding reforms. Today in Queensland, we have the Surrogacy Act 2010, which governs surrogacy in the state. Prior to this, many families sought overseas surrogates, which led to significant questions of citizenship and parentage rights.
So what is surrogacy? It's really important to remember that surrogacy is not as straightforward as someone carrying a baby for someone else. It is an emotional journey that not only affects the intended family or couple that may be struggling to conceive, but is a broader community issue that touches Australians across all walks of life. A surrogacy arrangement is an arrangement between a woman, the birth mother, and another person or couple, the intended parents, where the birth mother agrees to become pregnant with a child for the intended parents. If all goes to plan after the baby's birth, the birth mother gives the baby to the intended parents. A partial or traditional surrogacy involves using the egg of a surrogate herself. It can be fertilized by sperm from the father of the couple commissioning the surrogate or from a completely unrelated donor. The surrogate mother, in that case, is the biological mother of the child. By contrast, total or gestational surrogacy involves taking an embryo created from the egg and sperm of the commissioning couple or from a donor unrelated to the couple or the surrogate and implanting that into the surrogate. The surrogate mother would have no genetic connection to that child.
Now that surrogacy is legal in Queensland via the passing of the Surrogacy Act 2010, that does not mean that all forms of surrogacy are legal. The paramount guiding principle underpinning the Surrogacy Act is that of the well-being and best interest of the child born as a result of the surrogacy. The main rule of the surrogacy arrangement is that the arrangement must be altruistic, meaning there is no payment in exchange for the surrogacy service itself. Payments can be made to cover the associated medical costs only. A commercial surrogacy arrangement occurs when a person receives a payment, reward, or other material benefit or advantage for carrying that child for the intended parents. Although she cannot profit from the surrogacy arrangement, the birth mother is entitled to the reimbursement of the surrogacy costs, which is outlined in Section 11 of the Surrogacy Act. These include, for example, reasonable medical costs related to the pregnancy and the birth of the child, counselling and legal costs associated with the surrogacy arrangement, actual lost earnings because of leave taken during pregnancy or following the birth, reasonable travel expenses incurred throughout the pregnancy. The surrogacy arrangement is not legally enforceable. However, obligations to pay a birth mother's surrogacy costs are enforceable unless she chooses not to relinquish the child to the intended parents. The altruistic arrangement is made difficult because it is also illegal to advertise to seek a surrogate. There are various support services available to families via social media, for example, for finding egg donations and surrogates. These resources will be linked in our handout material provided to you today.
So if you're lucky enough to have found a willing surrogate and an intended family, there are still many hoops to jump through before the arrangement is final or before the surrogate arrangement can even begin. If you are an intended parent living in Queensland or a surrogate caring for Queensland intended parents, the Surrogacy Act 2010 applies. The criteria for surrogacy in Queensland includes that the intended parents have a social or medical need for the surrogacy. This includes same-sex male couples and opposite-sex couples who cannot conceive or carry a baby themselves. This is outlined in Section 14 of the Act for your information. Interestingly, an eligible woman under the Act who is able to conceive a child can still claim a need for a surrogate on the grounds that they are unlikely to survive the birth or could potentially conceive a child with a severe genetic condition linked to the maternal egg. Another criteria is that the birth mother or the surrogate is over 25 years of age. Also, each of the intended parents must be at least 25 years old. Also, the arrangement, as my colleague mentioned, must be altruistic. The intended parents must cover the birth mother's out-of-pocket expenses in accordance with the law. And we cannot stress this enough, but commercial surrogacy is illegal. Also, another criteria is that the parties have undergone counseling about the arrangement with a qualified counselor. Also, the parties need to have obtained independent legal advice about the arrangement. It's really important that they do that, and we provide services such as that. There must be a written surrogacy agreement signed by all the parties. Now, if you have a couple that meets the criteria or a person that meets the criteria for becoming a surrogate, it's important to note that the laws in each state are different where you're practicing as medical professionals. And as I mentioned before, the criteria that I've just spoken about are relevant criteria for Queensland.
Section 16 of the Act gives the right to the birth mother to manage the pregnancy and the birth as she sees fit, despite what the parties agree to in the surrogacy arrangement, which is done in writing. As with any normal pregnancy, the surrogate mother is able to make the decisions around her pregnancy. You may be surprised to learn that Section 15 of the Act tells us that a surrogacy arrangement is not enforceable, but is still an important step in the surrogacy arrangement.
Sometimes, unfortunately, a surrogacy arrangement does not go as planned. The birth mother may refuse to give away her rights after the child is born. As the child's interests are paramount, a court would then step in to determine who has custody of the child using the criteria spoken about in Section 6 of the Act, mainly focusing on the safety and stability of the home life for the child and a promotion of openness and honesty about the child's birth parentage. And of course, it's very important, the court will assess the child's emotional, mental, and physical well-being when determining who will raise that child. This applies regardless of how the child was conceived under the arrangement, and will especially consider the genetic relationship between the parties. So whether the birth mother has a genetic connection to the child or whether the intended parents are genetically related to that child.
So what happens if all goes to plan and the surrogate delivers a baby, or two? At law, the birth mother and her partner, if she has one, are the legal parents of the child. The Surrogacy Act 2010 provides a mechanism for transferring parentage, so the intended parents become legally recognized as the parents of the child born as a result of the surrogacy arrangement. Under the legislation, a parentage order may be sought from the court with the consent of all parties. The effect of a parentage order is that the child becomes a child of the intended parent or parents, and parentage of the child is removed from the birth parent or parents. The intended parents may apply to the Children's Court for a parentage order once the child is between 28 days and 6 months old, or at a later time with the court's leave. the child must be residing with the intended parent or parents, have been residing with the intended parents for 28 days prior to the application being made, and be residing with the intended parents at the time of the hearing.
To grant a parentage order, the court must be satisfied that the order will be for the well-being and in the best interests of the child. As part of the application, affidavits from all parties, legal advisors, medical practitioners such as yourself, and counselors demonstrating that the requirements of the Surrogacy Act have been satisfied must be provided to the court. In addition, a surrogacy guidance report must be provided by an independent counselor who will interview the parties for purposes of the application. The counselor must form an opinion about the parties' understanding of the implications of the proposed parentage order, and having regard to the care arrangements proposed, whether the order would be for the well-being and, once again, in the best interest of that child. Now, if any of the requirements outlined in the Surrogacy Act, Section 22, cannot be satisfied because, for example, the surrogacy arrangement was commercial, which is a no-no, the court cannot make a parentage order. In that case, the intended parents, their only recourse would be to seek a parenting order under the Family Law Act. And while the parenting order may confirm parental responsibility on the intended parents, it does not transfer parentage. So that parentage still lies with the birth parents or birth mother and her partner. So it can really get complicated. As we mentioned, it's really important for the community that you serve that you're well informed about surrogacy. And there are many impacts of surrogacy on, for example, people who are experiencing infertility. It's very distressing to find that out and to start the journey to seek a surrogate. As we know now, same-sex couples are able to get married in Australia, but there are clear physical hurdles for some of them to start families of their own. So understanding their rights and obligations around surrogacy is key. A lot of families may have heard really terrible stories about overseas international commercial surrogacy arrangements, and so being well informed around the rights and obligations of the parties is really important for you as healthcare providers to put people's mind at ease, or to obviously give them fair warning about the complications of what can happen if they choose that route. Also, Australia does have really strict adoption laws. So surrogacy is really important for people who may have thought they would adopt, but can't wait or can't go through that process and want to go down the surrogacy path. So once again, as medical professionals, it's really important to stay informed, guide the patients you serve to seek the correct advice, and to help people who may want to seek a surrogate arrangement. And once again, my colleague and I are here from the Community Legal Service to provide you more information around how to help.
As we have now covered the high points of the law surrounding surrogate arrangements in Queensland, we request that when advising families seeking surrogacy arrangements through medical professionals such as yourselves, that in addition to checking that the intended surrogate and intended parents qualify for surrogacy and are medically fit for surrogacy, that you also provide or arrange counselling, and also refer the parties to get independent legal advice. We are here to help by providing information and links to services available to help you better serve the community.
Finally, and out of interest, we've talked about the Queensland surrogacy laws today, but we'd also like to point out a few key differences from other states and territories across Australia around their surrogacy laws. Most interestingly, in the Northern Territory, there are no laws regarding surrogacy at all. So that could seriously complicate things for couples or surrogates in the Northern Territory. Also, in the ACT, traditional surrogacy is not allowed. So, in other words, the surrogate mother cannot be genetically related to the child. In WA, gay couples are not allowed to seek a surrogate still. That's in the process of being reviewed, but at this point, that's still the case. in the ACT and South Australia do not allow single people to be an intended parent in a surrogacy arrangement. So if you're a single mother or father, you're out of luck in those states and the ACT for seeking a surrogate. Also, South Australia and Western Australia do allow couples to advertise to find a surrogate. So unlike Queensland, where you're not allowed to advertise that you're seeking a surrogate or to advertise that you are available to be a surrogate, in South Australia and Western Australia you can do that. So it's quite interesting. And there are calls to have more uniformity across all the states and territories in Australia to make this all a little bit simpler. But as we're here today to inform you of what the case is in Queensland, and we're staying behind afterward if you have any questions. And you can also check out our blog, which we'll provide to you in our materials today, which will have more information regarding surrogacy in Queensland. Thank you for your time.